I just did a little bit here a minute ago and deleted it. I'm going to try to make it a little cleaner. Going to give you an update here. Last week there was a couple meetings in Salt Lake that I went to. One was with Representative Mike Noel. There was also representatives there from different senators, congressmen. Commissioner Lyman was there. Several attorneys, things like that. The discussion on that meeting was concerning the information they had found about some new information on Recapture. Recapture Canyon has a pipeline down it. The issue during the trial was that the protest had taken place on the road in Recapture Canyon that went along the pipeline down to where the pipeline leaves the canyon. People turned around and left. That was the part we were charged with. During the trial, Jared Bennett, the U.S. attorney, made statements and assumptions, anyway, and implied to the jury and the court that that was a Title V right-of-way for the Water Conservancy, and that the Water Conservancy could not authorize a third party to use that road. If that was a Title V right-of-way, then that is true. They cannot do that. The problem is it's not a Title V right-of-way. It never has been a Title V right-of-way. The BLM has never issued a Title V right-of-way to the county, to the Water Conservancy at all down Recapture Canyon. The road that he's referring to is a county road, and the BLM refers to it as a county road in several different documents. They did when they issued a right-of-way to a gentleman that was placer mining down there in the 90s. He placer mined until 2009. He was still mining in the canyon, in the closure area, after 2007. He had a right-of-way down the canyon that he had applied for. He got a Title V right-of-way, and in that Title V application, or in his application, he asked for permission to put in a road to his mine from the county road. At the time, the BLM acknowledged that being a county road, and that he could put in that right-of-way, or he could put in that road to his mine, so he did. In 2011, Maxine Dieter, here in the Monticello office, wrote a letter to Norm Johnson telling him that the county needed to apply for a Title V right-of-way so that they can maintain the water pipeline and everything. And Norm Johnson said, why do we need to do that? We got a county road we use. And basically it come down to Norm just saying, no, we'll just use the county road. The county road doesn't even, in that lower part in the closure area, it's probably, in most places, it's over 100 feet at least, if not more, away from the pipeline. There's quite a space in between them. So the pipeline and the county road don't follow right on each other through that closure area at all. Yet, in the trial, now, and to go back a little bit, we always said that it was a 2477 road. We have documentation showing it going back to 1880. That there's a road running up Recapture, and that it's always been a county road. And that was the claim we were making, and that was the defense we tried to put on. At the time of the trial, the judge said we couldn't put on that defense. We couldn't put on the defense that it was a 2477 road. We couldn't talk about that. We couldn't talk about the closure being illegal. And he did just automatically that the closure was legal, and that we could not talk about any of that or any kind of evidence to that effect. And if we didn't like it, we could take it to the 10th Circuit. That was his response. Well, we didn't like it, but there wasn't a whole heck of a lot we could do at that point. And so during the trial then, Jared Bennett, the prosecutor, he implied to everybody that it was a Title V, basically lying to the court. He knew it wasn't a Title V. The BLM knew it wasn't a Title V, because in these meetings we had last week, we had one with the BLM in Salt Lake with the new director here over the state, and basically asked specifically, is there a Title V right-of-way in Recapture Canyon? The answer was no. With all the documents they had there, the answer was no, we do not show a Title V in these documents. We'll go check everything else to make sure, but as of what we see here, no, there's no Title V. So there's never been a Title V. Yet Jared Bennett, in court, lied that there was, said that the Water Conservancy couldn't give us permission on a Title V when it wasn't a Title V. It was a county road, which they have every right in the world to give us permission on. So he misled the court on that. Plus, he misled the court when he told everybody, told the jury at the closing that Ferd Johnson, who gave permission to Phil Lyman, was lying, that he was probably lying. That's exactly what he said. He said, I don't even think that meeting happened. I think Ferd was lying. Well, he can't do that. There should be a judicial review of his unethical behavior there, plus his unethical behavior of lying to the court and misleading the jury. The jury thought we didn't have permission. We didn't need permission because it was a county road, and the courts knew that. The prosecutor knew it, the BLM knew it, they all knew it. The other thing is because it was a county road, the BLM had no authority to close it. They had no authority to close that road. That road was never closed, just like what we've been saying for years. Despite all that, they lied about it, manipulated it around, worked the courts around to where we couldn't even enter a defense, and we got convicted of doing nothing because it is a county road, it's proven, it's documented, and their people knew it. And the prosecutor, U.S. attorney, lied about it. And so did the BLM. Well, we've got the proof now, but now what do we do? You know, we're in our appeal, we'll file some paperwork there, but you talk to an attorney about it, and they're, oh, is it going to make a difference? Probably not, because no one gives a shit. Justice is nothing. I mean, there is, you know, when you think about justice in the judicial system, you might as well be thinking of fairy tales and faraway lands, because justice has nothing to do with it. When you got a prosecutor, a U.S. attorney prosecutor, that's going to sit there and blatantly lie to the jury, to the courts, about what's going on to cover up so that they have even grounds to charge you, because if they didn't do what they did, they don't even have grounds to charge us with trespassing. We were not trespassing. We were on a county road that they have no authority over because it's a 2477 road. And they know it. They know it today, and they're hiding it. But we've got them to finally say that they don't have anything showing that it was a Title V. So they've never issued a permit for that road. And that road's there, and they acknowledge it in their documents. It's a county road. So, anyway, that's what's going on right now. That's what we're trying to do. We're trying to write up, trying to get the word out on it. It's crazy, and mostly people probably won't care, but nothing like a railroad. And having your government just run you into jail and into fines and all kinds of stuff over absolutely nothing because you didn't violate the law, and yet they make it up, you know, as they go, and it's just all a lie. So we'll see where it all goes. But anyway, that's what the update is.